Start. There are two other considerations to which reference must be made. Stop. In its judgment, the High Court has observed that the oral evidence admittedly did not support the case against the respondent. Stop. The use of word admittedly, in our opinion, amounts somewhat to an overstatement, and the discussion that follows this overstatement in the judgment indicates an attempt to appreciate the evidence which it would ordinarily not be open to the High Court to do in writ proceedings. Stop. The same comment falls to be made in regard to the discussion in the judgment of the High Court, where it considered the question about the interpretation of the word Chhatarpur Sahib. Stop. The High Court has observed that in the absence of a clear evidence on the point, the inference drawn by the tribunal that Chhatarpur Sahib meant the respondent would not be justified. Stop. This observation clearly indicates that the High Court was attempting to appreciate evidence. Stop. The judgment of the tribunal shows that it considered several facts and circumstances in dealing with the question about the identity of individual indicated by the expression Chhatarpur Sahib. Stop. Whether or not the evidence on which the tribunal relied was satisfactory and sufficient for justifying its conclusion would not fall to be considered in a writ petition. Stop. That, in effect, is the approach initially adopted by the High Court at the beginning of its judgment. Stop. However, in the subsequent part of the judgment, the High Court appears to have been persuaded to appreciate the evidence for itself, and that, in our opinion, is not reasonable or legitimate. Stop. The High Court has also commented on the fact that the tribunal should have examined Benjorji before relying upon statements made by him in his letter addressed to Mr. Patnaik. Stop. There is some force in this argument, but the finding of the tribunal in regard to the purchase of the Austin car is based on several other considerations, all of which have been duly proved. Stop. In fact, about the main features of this transaction, there was no serious controversy between the parties. Stop. The parties were at issue on the question as the effect of these borrowed features, but that clearly is a question of the fact which fell within the jurisdiction of the tribunal. Stop. We have carefully considered the reasons given by the High Court in its judgment under appeal, but we are unable to accept the contention pressed before us by Mr. Sinha for the respondent that the conclusion of the High Court is right when it says that the tribunal's findings against the respondent were based on no evidence. Stop. Over.